Well, good afternoon and welcome to the Center for Comparative Immigration Studies. My name is David Fitzgerald, and together with our co-hosts at the UCLA Center for the Study of International Migration, we're happy that you've joined us for today's Friday Migration Book Seminar Series. Next week, at Friday at the same time, we're going to be discussing the new book by Christina Rodriguez and Adam Cox, The President and Immigration Law, with a comment by Hiroshi Motomura. Info on all of the speakers in our weekly series are available on the websites of the two centers. But today we're delighted to have with us Shoba Wadhia. She is Associate Dean for Diversity, Equity, and Inclusion and Clinical Professor of Law at Penn State. We have also Ingrid Eagly, who's Professor of Law at UCLA as a discussant, and we're going to be discussing Shoba Wadhia's new book, Banned Immigration Enforcement in the Time of Trump. The plan today is that we'll hear about a 20-minute presentation by Professor Wadhia, a comment by Professor Eagly, a quick response, and then we'll open things up to a Q&A. During the Q&A session, please just electronically raising your hand, use the raise your hand function at the bottom of your screen, and I'll moderate that discussion. So as you know, if you've joined us before, all of our sessions are recorded. They're available on the web afterward if you'd like to share them. But we could not have a more timely topic than today's discussion in the waning days of the Trump administration, looking forward to policy under a new Biden administration. So Shoba, what can you tell us about immigration enforcement in the age of Trump?
Thank you so much for inviting me to be here. I'm honored and also excited to be delivering my first book talk in a Biden-Harris transition. But in the book Banned, I really document the story of immigration in the time of Trump, and really, for me, how this story is told to future generations is really going to matter. 10 years from now, this will be a chapter in the history books, and the documentation of the story is one impetus I had in writing it. I spoke to many different people in writing this book, including former agency heads, Daca recipients, immigration attorneys on the front lines. And my goal was to surface the emotion behind these policy changes, explain the law in accessible language, and offer concrete ideas for moving forward. So I want to start with one chapter in my book that's called Everyone is a Priority. Enforcement priorities really refer to a group of people that the government identifies as the highest target for removal. The government has resources to deport about 400,000 or less than 4% of the undocumented population. So choices have to be made. Who will the government deport? Who will it leave alone? And historically, the people who are left alone are those with equities like lengthy residence, humanitarian needs, family ties in the United States. This kind of discretion is really essential to a functioning immigration system. In the Trump administration, we've seen enforcement priorities look a little different. For example, guidance lists, for example, those with old removal orders as actual priorities, without even mentioning discretion, how it can be exercised, or equities that could be considered. In addition to these broader executive orders we saw were the words coming from leadership. Former Immigration and Customs Enforcement head Tom Homan said, quote, "There's no population off the table. If you're in the country illegally, we're looking for you." And these words really translated into tragedy on the ground. One immigration advocate I interviewed told me, quote, "Everyone is a priority. It doesn't matter if you've been in the country 20 years and you've never committed a crime and you're on your way to Sunday school. You are a priority," end quote. In the time of Trump, immigration enforcement has also extended to other branches of the government that are not typically involved in deportation. As one former INS, or Immigration and Naturalization Service head, told me, quote, "You see an enforcement outlook and actions that US Citizenship and Immigration Services is taking that would have never happened in the INS days. People today can go in for a naturalization interview and come out in handcuffs, subject to deportation. That would have never taken place at INS. And one of the reasons is not just that it was a different era or a different administration. It was that if people were eligible for benefits, the view was that they should be given the opportunity to have their cases reviewed. The expansion of enforcement priorities, or the abandonment of them, as documented in the original edition of Ban, lingered until the global pandemic. In March 2020, ICE published a policy on their website that limits immigration enforcement to those who pose a public safety threat or those subject to mandatory detention for criminal reasons. This enforcement shift or limitation was significant in theory, but its legitimacy was undermined by the continued detention of immigrants in ICE facilities, the choice by the administration to deploy DHS employees to rallies around the country at which individuals were protesting the deaths of George Floyd, and other Black men and women at the hands of police officers, and continued deportations. Deporting dreamers, another chapter in my book, and closely related to discretion because how we treat dreamers is associated with enforcement priorities. Daca is a policy that was announced in 2012 by former President Barack Obama. It was implemented by then Secretary of Homeland Security. And to qualify, people have to have entered the United States before the age of 16, be in school or graduated, show that they meet other requirements. Qualifying Daca recipients are protected from removal through a type of prosecutorial discretion called deferred action. And this deferred action period runs 2 years and also provides a basis for work authorization. It's been a gateway for 800,000 immigrant youth. The Trump administration announced an end to Daca on September 5th, 2017. And the announcement was delivered by the Attorney General at a press conference at which he called dreamers illegal aliens and the Daca policy unlawful. One Daca recipient I spoke to used her lunch break to listen to Sessions' speech. And she said to me, just hearing everything that he said, knowing that was such a lie, such an excuse, such bull, it was a pretty defeating, dehumanizing moment. Another Daca recipient I spoke to talked about the mental toll. And he said to me, I think it's not so much the effect of the policies that are being enacted, which are dangerous and poisonous to our democracy, but it's the psychological warfare that we're subjected to on a daily basis. We live in a time where the president can just pick up the phone, send out a tweet, and then you spend the whole day deciphering it. How bad is it? How bad isn't it? That's followed by really bad actors across all agencies that are trying to diminish any sort of real idea that this nation continues to be a nation of immigrants. On November 12th, the Supreme Court heard oral arguments in the Daca case and asked the parties to answer 2 questions. First, is the Daca case reviewable? Second, if the answer is yes, is the way Daca ended lawful? On June 18th of this year, the Supreme Court, by a 5-4 vote, concluded that yes, the case is reviewable, and no, the way the administration ended Daca was not lawful. Rather, it was arbitrary and capricious under administrative law. While the Supreme Court handed a victory to Daca, the implementation of the decision has been complicated, in part by a memorandum from DHS setting its own limits and terms to the Daca policy in ways that defy the Supreme Court. So in this chapter on Daca, I also bridged and connected it to 2 other populations who have been vulnerable to enforcement in the time of Trump. Those who hold TPS, or temporary protected status, as well as those who are in deferred enforced departure, or DED. And the ties that bind DACA recipients, TPS holders, and DED holders is that these are populations that are here temporarily. They've lived in the United States for over a decade, and they are vulnerable to deportation. In 1990, Congress created TPS for nationals of designated countries who can't return to their country for a specific reason, like a civil war or ongoing conflict. This is a durable status, but a temporary one, and one that the Trump administration sought to remove from hundreds of thousands of TPS holders. One immigration advocate told me, quote, "The government is actually taking people who have access to legal work authorization and have built their lives here and making them undocumented and deporting them." And this is an important point for two reasons. First, it shows us how the target of the Trump administration is not only people without papers, but also legal immigrants. Second, you see an attempt by this administration to create or expand the unauthorized population. Another chapter in my book deals with the Muslim ban. And the Muslim ban also highlights how legal immigrants recognized under the immigration statute have also been a target. It refers to three separate policies that were made by the president. Most of the nations targeted have populations that are overwhelmingly Muslim. The first was issued as an executive order in January 2017. And some of you might remember or may have participated in the activity that weekend where advocates and attorneys were deployed to airports. There was a lot of chaos, and part of the reason is that the executive order was issued with no guidance or training to those responsible for implementing it. The latest version of the travel ban was issued as a presidential proclamation, and it was survived in the courts. It's been operational since December 4th, 2017. And it excludes would-be green card holders and several travelers, even today, who are from Iran, Libya, North Korea, Somalia, Syria, and Yemen. The US Supreme Court upheld this version of the ban on both statutory and constitutional grounds. And the statutory premise that the Trump administration used to implement the travel or Muslim ban was a section of the immigration statute called 212F. And I want to mention it because 212F is a section that keeps giving or taking away, however you determine that. It says specifically that the president may suspend the entry of any, quote, alien or class of aliens, end quote, if such entry would be detrimental to the interests of the United States. And Chief Justice Roberts found this language to be broad and language that exudes deference to the president in every clause. One attorney I spoke to described the case of an Iranian physician who gave birth to twins whose parents could not travel to the United States. She said to me, to not even be able to hold their grandchildren, not support their kids who are doctors, it's hard. It's really, really hard on the community. She continued, the common thread I see among every single person that walks into my office is, I need my mom because I'm going to be in labor and I can't do this without her. Or I'm the first person in my family to get my PhD, and it would mean the world to my parents to be there at my graduation ceremony. Or I'm in love and I'm getting married and I'm getting engaged, and this is a huge moment in my life. And I would like my parents to meet my future husband. There are moments in our lives that we normally share with family, graduations, birth of a child, engagements, weddings, all of them destroyed for people because of the Muslim ban. And I want to say something about where I'm situated in central Pennsylvania. I teach at Penn State Law, and we are a campus to a very large community of international students and scholars. People might not normally think of rural Pennsylvania as a community deeply affected by the Muslim ban. But we were, in fact, the fourth most affected university in the country by the first version. And it's an example I use to really show how national policy can affect our own community. After Banned went into print, the Muslim ban was expanded to include nationals from 6 other countries, mainly African countries. So some people call it now the Muslim and African ban. It had an immediate effect. You know, one example of someone affected you can think about is a Nigerian. Nigeria was identified. So I got a call from a Nigerian national who was sponsored by a US employer, approved for a petition for a green card, but who was traveling back and forth from the United States to Nigeria for his business. And he was outside the United States the day that this ban went into effect. And as a result, blocked from entering. Also, since publication of this book is COVID-19. And we've really seen between January 2020 to March, and again, relying on this 212F clause that I mentioned from the Muslim ban, multiple policies published by the administration to block people physically present in certain parts of the world from entering the United States. And those regions of the world include China, Iran, the Schengen area, Ireland, and the UK. In April, the White House issued a new proclamation suspending immigration from the entire world, not just specific countries. And like with earlier administrations, that 212F clause was used. And the human impact, again, was profound. It would have blocked my own mother, who came to the United States as the spouse of a green card holder, from entering the United States today. So we see how what started as a ban targeting nationals from certain countries has only continued to grow. I now want to shift to a chapter in my book called Rejecting Refugees. And we might think about this population as among the nation's most vulnerable: asylum seekers, refugees, parents, children. One recurring theme throughout this book, and also with respect to refugee policy in the time of Trump, is that they reflect choices, discretionary choices, rather than legal requirements. One former INS official I spoke to said to me, to define refugees as a national security threat, we haven't thought that way for decades. So refugees are outside the United States. They seek admission. They have to meet several requirements, legal and procedural. And the president has enormous discretion to decide what the cap will be on the number of refugees who could be admitted each year. And in the time of Trump, we've seen those numbers at historically low levels. The numbers are fixed for 2021 at 15,000. We're fixed at 2020 for 18,000. Contrast that to previous administrations, both Democratic and Republican, where presidents are more in the ballpark of 70 to 110,000 when it comes to refugee ceilings. Now let's talk about protection here in the United States. Individuals who are physically present in the United States apply for asylum. They too have to meet the refugee definition. But we've seen multiple restrictions to asylum in the time of Trump. So I talk about Jeff Sessions' zero tolerance policy. And he said, I quote, "If you cross this border unlawfully, then we will prosecute you. It's that simple, end quote. And this is a policy that extended to asylum seekers, where a parent and a child, or a parent or multiple children would arrive at the border. The parent would be referred to a US attorney for prosecution for unlawful entry. The child or children would be reclassified as unaccompanied minors and then separated from their parents. And so there was a close connection between the zero tolerance policy and family separation. But what has become evident through litigation, as well as very recent oversight reports and testimony, is that the Trump administration had an affirmative policy to separate parents and children. And even today, there are a number of parents who have not been reunited despite litigation ordering the administration to do so. Other restrictions to asylum have been procedural, but these procedural changes are in fact substantively significant. So for example, a policy change to block asylum to people who arrive in between ports of entry or at a place other than a port of entry. Similarly, a policy known as the transit rule to block asylum to people who might pass through another country before they arrive at the southern border. And this is something I saw all the way in central Pennsylvania when our clinic went to Berks County Residential Center, which is one of 3 family detention centers in the country, and where families were being outright denied asylum eligibility because of the way they entered the United States. I think the final policy change and conversation in my book that I'll talk about before doing a speed through some solutions, and this term is appropriate, is speedy deportations. And this is crucial because in addition to thinking about who we target for immigration enforcement or deportation, is this question of how we deport and enforce immigration law. And in June 2018, President Trump tweeted, "We cannot allow all of these people to invade the country. When somebody comes in, we must immediately, with no judges or court cases, bring them back from where they came. Our system is a mockery to good immigration policy and law and order," end quote. I mean, what's interesting about this tweet from the president is that we now write books that in fact use the word tweet. And second, that the immigration statute already has a framework for quickly deporting people. And in fact, the vast majority of people who are deported from the United States are done so through a speedy deportation program. But the Trump administration really did state through executive order and narrative its desire to maximize it even more. So where do we go from here? I think that we've all seen the courts play a really significant role in rolling back some of the immigration policies in the time of Trump. But my position is that the courts are not going to save us. They certainly didn't save us with the Muslim ban. And more importantly, a lot of these solutions lie with the executive and with Congress. And I want to just talk a little bit about the executive, because hearts and minds are on what an executive can do if we think about the first days of a Biden-Harris administration. And to my benefit, they align quite nicely with some of the solutions that are detailed in my book. And so one of those solutions, and I'm going to just put this slide up here, are to really undo some of the bans that we've seen. So we saw an announcement by President-elect Joe Biden that he will rescind the Muslim ban on day 1. And so I've been getting a lot of questions of how do you do that, right? And because it was issued as a proclamation, it's one of those tools or policies that are easier to take away. I don't want to overstate that point though, because the separation that has already taken place with families who are already separated through the ban, those milestones I mentioned, like births and engagements that parents have missed, those cannot be returned to those families. But there is a fairly quick way to rescind the bans. Similarly with Daca, where we see an attempt by the Trump administration to move away from a full restoration of Daca, we have the possibility of a maybe even broader use of prosecutorial discretion when it comes to dreamers and to other populations who might benefit from deferred action. And maybe I'll end by talking about how we think about enforcement priorities and the importance of listing factors and equities that have long informed discretion in the immigration system and returning to the use of compassion and these equities when we consider what a prosecutorial discretion policy looks like moving forward. So I'm going to stop there and thank you so much for your attention. And I'm really looking forward to comments from Professor Eagly.
Thank you very much. Ingrid, the floor is yours.
Great, thank you so much. I want to thank the organizers for inviting Professor Wadhia here today, and thank you so much for your amazing book that is just an incredible contribution. I want to encourage everyone, this is really a must read. It contains such rich detail. It draws on really impactful interviews with a wide variety of players, including individuals who are themselves immigrants and impacted by the policies of our current president. And classic to Professor Wadhia's academic style, it's very clear, beautifully written, and really makes sense of a very complex area of law. So something that really drills down on essential policies in a very clear and helpful way, which is a big accomplishment in this area. So there's been really a monumental number of changes during the Trump administration. Yet, in this book, we really see a concise summary and catalog of many of the most important ones and the way in which they are directly impacting the structure of the immigration system and refugee system, as well as, individual lives that have been impacted. This is a really great time for our this book talk because as we transition to a new administration, we're seeing the possibility for a new set of policies. And it's also a time where our Vice President-elect Harris has an inspirational family story as herself being the daughter of 2 immigrants and someone who during the Democratic primaries went further than President-elect Biden in terms of her proposals, which included arguing that unlawful entry should itself not be a crime, and also proposing some new rules that would define separation from a close family member to qualify as extreme hardship, which would be a dramatic expansion of cancellation of removal, a form of immigration relief that is also discussed in Ban. Of course, any strategy would require executive actions, Congress, retooling of government agencies, and also support by the courts, which have been fairly dramatically restaffed under the Trump administration. I want to use my brief time to just highlight 3 topics that are discussed in the book that I think are particularly salient as we think about this transition in administrations: executive action, prosecutorial discretion, and then also immigration courts, or the sort of inverse of immigration courts, speed deportation. I'm not expecting responses to the questions that I raised, but really try to generate discussion as we open it up to the group that is participating. So one of the topics that's been discussed extensively in the book is the extent to which the president has the authority to sustain, change, or terminate existing immigration policies. Obama, of course, used the presidential power, and Daca is a powerful example of that. And Trump signed, as you've already discussed, many executive orders, including executive orders suspending refugee admissions. You explain, in the final remarks about how, the president and, President Biden could sort of undo these. We could unban Muslims. We could reaffirm support for Daca or for TPS, again, through presidential action. And I think this also connects to a book talk that we're looking forward to coming up with Professors Rodriguez and Cox on the president and immigration law. In their book, they highlight that, one of the biggest many of the biggest controversies in immigration law in the last decade have all involved these policies that are promulgated by the presidents through executive actions. So we can critique sort of one set of those policies and applaud another set of those policies. But I think that, having these policies come through from a president does cause some, pain and uncertainty. I loved the quote from a dreamer that you interviewed, who says, "We live in a time where the president can just pick up the phone, send a tweet, and then you spend the whole day deciphering it. How bad is it? How bad isn't it?" That's followed by really bad actors across all agencies that are trying to diminish any sort of real idea that this nation continues to be a nation of immigrants. So, a very powerful quote that goes toward the particular policies, but I think also sort of the uncertainty of having policies, wiped away with the stroke of a pen or a tweet. So I think one of the important things to be thinking about is, if we as we move toward a Biden administration, how many of these policies will be undone by executive order? And then what is the possibility of, having other kinds of structural changes through action of Congress? The second topic that's incredibly interesting is prosecutorial discretion. And I think this builds so well on another of your books that I want to encourage everyone also to read, your prior book, Beyond Deportation, The Role of Prosecutorial Discretion in Immigration Cases. And in that book and this book, you talk about how Obama cabined immigration priorities to sort of focus on those who would be national security risks or those with criminal convictions. This was outlined in a 2014 memo that sort of set forth those priorities, and also when and how to carry those out, preserving certain sensitive locations like schools and churches to be safe from immigration enforcement. Trump, of course, has reversed all of these policies, and we see that dramatically also in the prosecution of asylum seekers and the so-called zero tolerance policy. So now as we're in this different administration, we can sort of narrow those priorities, eliminate enforcement at sensitive locations and the prosecution of asylum seekers, all very ambitious and important proposals. But I also am struck by, the Obama administration also was sort of labeled the deporter in chief, deported more immigrants than any other administration and prosecuted a record number of border crossers. One book here that has been influential for me is Bill Hing's book that looks at American presidents and deportations from Carter to Trump and sort of the arc of the severity in immigration enforcement. So I'm wondering, as we think about these new proposals of how to change the use of prosecutorial discretion, are we thinking about a policy that just brings us back to the Obama administration, or are we thinking about policies that would reform and tailor further so that the Biden and Harris administration actually does look different? And then the final area is one that, I know a lot of my work touches on as well, and I really appreciate this part of your book, and that is looking at the immigration courts. Here we've seen dramatic changes in immigration courts under the Trump administration, the Attorney General reversing established precedent, such as in matter of Castro-Tum, taking away the ability of immigration judges to administratively close cases, which is a docketing tool that has traditionally been used by immigration judges, and enforcing quotas that immigration judges have to follow to ensure that they get a satisfactory review by their boss. You interviewed Dana Lee Marks. This is another quote that I just wanted to touch on very briefly. She's, of course, a very well-known and respected immigration judge in San Francisco and formerly head of the Immigration Judges Union, which was just recently threatened with decertification. And she says that these policies, including the quotas that have been imposed under the current administration, I have a duty to afford every individual who comes before me due process. So I have to give that individual the amount of time they need in order to complete the case, which is before me. What this quota is going to mean is that when I deny a continuance, or I say that one more witness is duplicative and not necessary, the people before me are going to ask, is Judge Marks making a decision based on her own legal judgment, or is she concerned about trying to improve her own personal performance rating? A very real concern, and a concern that really undermines trust in immigration courts and the rule of law. That judges don't have time to spend on their individual cases, and that's really by design by all of these policies that have been imposed on immigration judges, taking away their authority. So the Biden plan, part of his first 100 days is to reverse many of these policies that are impacting immigration courts. And you also propose a sort of a more ambitious plan in your book, which includes the independence of immigration courts. And so that's something that I wanted to, hear more about. Do we think that's feasible? And do we think that a Biden-Harris administration could possibly get that done? So I want to end there. Again, I just applaud you and thank you so much for this wonderful contribution and for coming and sharing it with us today.
Thank you, Ingrid. Shoba, would you like to briefly respond?
Sure. Those are all great comments. And I really should, I hope the crowd already knows how instrumental Professor Eagly's own work in a lot of these areas have been during the time of Trump, so that we have the numbers and the empirical data also to dispel many of the narrative that we have heard in this administration. I want to talk about what I think I first heard about, just the use of discretion, kind of one president to the next, right? Where we have the Obama administration wielded presidential power, and you didn't ask it in this way, but I will sort of add to what I think might be the question. Well, isn't that the same kind of power being wielded by the Trump administration? And then it goes to the next and the next. And when is it legitimate? What is enough? What is too much? And I think that when I think about the question, it's really about how discretion is used. So I think that discretion, and this is part of my own value, that I believe that when discretion is used, especially given the current statutory framework, it should generally favor the non-citizen, right? Because it is a powerful tool in an already robust statutory framework. So there are differences if I think about how prosecutorial discretion policy was drawn by the Obama administration and the way that discretion was used on both a micro and a macro level by the Trump administration. It wasn't used to keep families together or in consideration of equities or to favor someone who's been here in the United States for long periods of time, but instead used to restrict, to exclude, to deport. On the second question, which is also related, right, is the solution to just go back to the Obama administration, right? Do we return to the 2014 prosecutorial discretion policy? What about the fact that there was a record number of deportations? So I think I have two reactions to that. The first being that the Obama administration does not provide us with a perfect immigration policy. And so rubber stamping what took place during his tenure may not be and is not the solution we should be looking for or the ways that we hold a new administration accountable. And I think related to that is just, we're in a new world, right? We are in a landscape where the scale of harm is something like we haven't seen before. The scale of immigration enforcement, the greater and heightened attention to the intersection of race and immigration, these are things that just cannot be ignored when we think about what policy change looks like in a new administration. And I think the same sort of dramatic sword that the Trump administration pulled to enact these policies may be the same dramatic sword that needs to be used for us to rethink these policies overall. Family detention is an example of that. As you know from your work, there's no real rationale for why we detain families. It's existed over many administrations, but it's discretionary. There's no legal requirement to detain families. So a new way to think about it is, what does it mean to no longer hold families in detention? And like that, I think there are other pieces where we need to take a fresh look at immigration reform moving forward. And then finally on immigration courts, which I don't spend a lot of time on, there is such an urgency for greater independence given the degree to which that independence has been taken away from immigration judges in the time of Trump. Politically, I think it's going to be difficult. I think it's going to be difficult because that's going to require legislative crafting. I know that after 9/11, before I was an academic, I was a lobbyist, I was working on different types of immigration legislation. And one proposal was just to pull the immigration court out of the Department of Justice, and to make it just an agency. And even that was a very difficult lift. So I think any kind of legislative change that changes the structure, it's possible, but it has more challenges than some of the executive policy changes we've talked about. Thank you for those comments and questions.
Okay, thank you. For those of you who are on the call, if you have a question that you would like to pose, please use the electronic hand raise function and you'll be recognized. I have a question just to start things off, Shoba, which is, I know that you're a legal scholar, but you've also worked in the policy field. And as you assess the consequences of actual changes in the law vis-a-vis changes in discourse, say calling Mexican immigrants rapists and so forth, all of the norm busting, even raising the question of whether or not unauthorized immigrants should have access to the courts, even if that wasn't actually put into effect, calling asylum seekers bogus and scammers and so forth. How do you weigh the importance of those two things?
So we could write a whole separate book on narrative, right? I think the narrative and the terminology that's been used by the Trump administration has been damaging. And it's not unrelated to that psychological warfare either, and uncertainty that one person I interviewed highlighted. We've seen it collide with the legal discourse, right? When we saw some of the challenges that were made, not necessarily successful, but I think we saw for the first time and time again in lawsuits that animus was driving particular immigration policy and challenging that animus as a matter of law. So what kind of effect do I think it has as we think about immigration policy? It has a large one, and I think terminology matters and will always matter. And I expect that we will see a shift in how this new administration talks about immigration. And I'll leave it to the sort of social scientists to determine, how that might have a net positive effect on policy itself.
Thanks. We have a question here from Jacob Thomas, and summarizing, what if the Biden administration were to prioritize cases of immigrants who had committed felonies, who might be some kind of security risk, these kinds of cases, and if at the same time the government consistently took legal action to prevent further unauthorized migration through employer sanctions mechanisms and so forth, do you think that the public would support perhaps even higher levels of deportation as long as they really were prioritizing people who had committed more significant crimes or somehow did actually pose some sort of threat?
So that's a complex question, right? And the complexity predates the Trump administration. It's something I also talk a lot about in my first book, Beyond Deportation, in terms of how do we determine who is a high priority, who is a low priority, who do we deport, who do we leave alone? These are choices that we know have to be made economically because of limited resources. But looking 70 years back, we also know that equities really historically have informed that decision making. So I don't know that any element of criminality should suffice to being a priority for enforcement, or even any felony for that matter. And I think that part of that has to do with how I view the role of prosecutorial discretion and the importance of looking at the whole person and equities. Whether the public might be more satisfied if we target people who are, in the view of the administration, serious criminals, perhaps that's something we saw in the Obama administration, perhaps not, as we think about how we are talking about the criminal justice system and race today, which is just no longer unrelated to immigration enforcement priorities. So if there are problems that are structural and systemic, I think those conversations really have to surface so that it's not a sort of families, not felons language, and then we move on. Because I don't think that will be satisfactory to the public anymore. And I guess I'll end with what is, again, longstanding conversation in the immigration discourse too is, who do we label as a good immigrant? Who do we label as a bad immigrant? That's a complicated question. Dreamers don't want protection at the expense of their parents, for example. So what does it mean to have a solution that is inclusive, but also sensible?
And I'm sure you've seen this report. Our colleagues at the Migration Policy Institute have cataloged more than 400 changes in immigration policy under the Trump administration. Some of them have brought protesters into the street. You mentioned the airport cases, for example, related to the Muslim ban, travel ban. What are the policies that have not gotten a lot of front page attention, or which have not brought protesters into the street, but are really consequential and they're not really well understood?
Well, it's interesting you bring up the Muslim ban, because one thing I observed is people started getting Muslim ban fatigue, right? So you saw all the airports after the very first version came out of the administration, but then it just became hard to keep up, right? And I think that exhaustion was also intentional on the part of the Trump administration. So what proclamation are you on today, and who's affected, and what are the exemptions? I don't think that the continued implementation of the Muslim ban was overstated or in the public eye necessarily. Further, and this isn't something that I take up in my book, but I take up in later writing, is the notion of the so-called shadow docket in immigration, where the Trump administration has, in many cases involving immigration, in which it loses, sort of leapfrog to the US Supreme Court and ask the US Supreme Court to put a stop to the stop that a lower court has made on immigration policy, and been successful by a Supreme Court issuing an order that has a couple sentences that could be signed or could be unsigned. And it literally means that we don't have a normal court process anymore, right? The Supreme Court says, oh, President Trump, you lost. Well, we'll put an end to that, right? And we'll reinstate the policy you wanted all along. We saw that with the Muslim ban before the Supreme Court took it up. We saw that with the asylum transit rule. We saw that with public charge. Those are three examples of the shadow docket. And I also think that family separation has been off the grid to the extent that we know what that looks like and tastes like based on what we've seen in the media, parents and children at the border. But I think there are many untold stories of family separation in the Trump administration that doesn't have the same kind of flavor, right? Or hasn't been tasted in the same way by the American public. It's harder to tell the story of family separation in the Muslim ban because you don't see it, right? A lot of it is behind closed doors. Or with respect to the changes in enforcement priorities, if a greater number of breadwinners are being detained when they go into a routine check-in and then deported. So I think the many different flavors of family separation has also gone somewhat unnoticed.
Thanks. Here is a question from Faisal Buhari. Will increasing, let's see here. You know, as societies age, do you think there'll be a shift in favor among conservatives to reconsider their opposition to immigration? Perhaps to recognize the need for more younger workers to feed into pension funds and so forth to sustain the entire apparatus?
It's a great question. And we've had this sort of aging demographic for a while now, right? That continues to increase. And really what this question is about, though, is, you know, is this going to change hearts and minds, right? And that's a big question. And it may not even be a legal question. And I don't know that the evidence of an aging demographic alone will change hearts and minds. I think the need for labor from an immigrant by someone who then experiences the benefit of that immigrant labor could change their heart and mind. I think that a return to some kind of bipartisan debate and conversation, which did exist for many years around immigration, where you had many different political views coming together when it came to pragmatic solutions to immigration, could aid in a reconsideration or a movement forward on immigration reform. So I think it's a combination of these sort of micro connections that people have with immigrants so they can see the benefits and have the lived experience of those benefits, as well as the political will and the composition to return to a conversation about immigration. And that might just get back to your question about just narrative, right? We have to change the narrative on how policymakers are even talking about immigration in order to get to the evidentiary reasons for why we need immigration reform.
So, you know, one of the striking things about some of those court cases that you were talking about is that so many of them seem to be decided in favor of the immigrant advocacy organizations based on the argument that the administration policies were violating administrative law. And is it my imagination, or is that fairly novel? To the extent that it is novel, can you say anything about how that strategy developed or why it's been effective or not in particular sets of cases?
Yeah, well, I mean, I'm an administrative law nerd, so it's, you know, it wasn't an aberration for me as I was reading through the court cases and the arguments. I think that, you know, administrative law is about agencies, and choices that are made by agencies or the executive have to be reasonable and they have to be rational. And I think that we've seen with regard to many of the policies that were issued by the Trump administration, procedural bypasses, right? And those bypasses being, I'm not going to go through the notice and comment rulemaking requirements of administrative law procedurally and get public input and then consider those comments and then publish a rule. Instead, I'm going to announce a presidential proclamation. I'm going to publish an interim final rule that is immediately effective. And so I think that it just I don't want to call it low-hanging fruit because I don't think any of these lawsuits were easy lawsuits. But I think there's just a clear violation of process under administrative law. And the same is true for rationale, right? You can't just announce that Daca will end, that the policy is, unlawful, when it's never been ruled as unlawful in the history of deferred action. And then try to tie the logic, for example, of ending Daca to people coming across the southern border, right? There are just so many reasons why you can poke holes at the arbitrary nature of policy changes. And Daca is really a significant example because of the contributions of Daca recipients, right? And the benefits that they bring to the United States. It is a less sexy basis, right, for winning or being successful. And so it takes more unpackaging, right? People are more used to hearing, constitutional arguments, and that's more familiar to them than administrative law. And then there may be some constitutional avoidance, right? If there are arguments that can be raised under administrative law, or in other cases, immigration statute, because the immigration statute has also been a basis for legal challenges. For example, the Asylum Ban, it's a pretty clear violation of the literal language of the asylum statute that any person, regardless of how they entered, regardless of their status, can apply for asylum. There may be a little bit of that constitutional avoidance too.
Ingrid, do you want to jump in on any of these questions? I know that this also very much touches on your work.
Yes, I'm just unmuting. I wanted to just, I was hoping that, I talked a little bit about immigration courts, but I was wondering if we could talk just a little bit about speed deportations, because that's something that I think that you're critical of in your book. And I know you've also written other academic articles on the use of speed deportation. So expedited removal, reinstatement of removal, administrative removal. What do you see as, and reliance on this is also sort of discretionary. So do you think that there's anything that a Biden administration could do to sort of switch policy direction, or that Congress could do in this area as well?
Sure. And you can see that the sun from my window is shifting. I am not shifting. So we have this statute, and now I'm having a teacher moment, right? So here's the immigration statute. It was written by Congress in 1952, second in complication to the US tax code. And inside of this statute are 3 speed deportation programs that have been around for a long time. The 3 programs were nicely listed by Professor Eagly, but they basically allowed the Department of Homeland Security to deport a person before they see a judge, or without even stepping foot in a courtroom. And it's not intuitive, right? I think most people believe that before you are deported, you go into a courtroom and a judge makes a decision. But these speed deportation programs are significant because the agency acts as the prosecutor, as the jailer, as the judge, and the rules are statutory, and they apply today to people who arrive at the border without documents or false documents, to those who have committed certain crimes and are not green card holders, and to those who have an old removal order and re-enter, right? And so these 3 populations, which sometimes might even sound like dangerous populations, are in fact ones that might be your next door neighbors, or individuals whose children go to school with your own children. Several of the cases that our clinic has handled have involved people who are subject to one of these speedy deportation programs. So one thing that the Biden administration could do is to exercise its discretion to limit speedy deportation. So the statute doesn't need to change in order for a Biden-Harris administration to direct that the Department of Homeland Security and Justice limit their use of speedy deportation. So it's an example of a discretionary choice that can be used. There's always discretion by a line officer at the border to even decide to put somebody in expedited removal, right? So the same person who is legally eligible for expedited removal because they arrived at the border without papers, I could use my discretion to just place that person in regular removal proceedings. So I think that we can see those kinds of changes possibly at a broad level, right? Where, and we haven't seen this in any prosecutorial discretion policy as far as I'm aware, where the new administration says that as a matter of prosecutorial discretion, the Department of Homeland Security should generally avoid applying these deportation policies in favor of either not putting someone in removal proceedings at all, that's a lot of money, or issuing a notice to appear if relief is available.
Okay, we have a question from Maurilio Hernandez. Have there been any changes in visas or other procedures around victims of crime, immigrants who are victims of crime in this administration, or looking forward to what is likely in the Biden administration?
Sure, it's a great question. So there are a few different remedies and benefits that are available to survivors in the immigration statute. One that's gotten attention by the Biden administration is the so-called U visa. And this is a creature of the statute. Congress added it in the year 2000, and it allows for people, regardless of their status, to seek protection if they have been the victim of a crime and they are helpful to law enforcement in the investigation and prosecution of that crime. So that could include a survivor of domestic violence and sexual assault, or a victim of robbery, just to give you kind of the spectrum. It has been difficult in the Trump administration for a few reasons. There's still discretion in how agencies decide, right? What helpfulness looks like, for example. Second, we've seen some policy changes that suggest that law enforcement should limit when and if they certify these cases before a person applies at USCIS. You know, those things could be ameliorated, if not removed, in a Biden-Harris administration. Another change I see that could be of great benefit is to increase the number of visas that are available for you victims or survivors. Currently, the statute sets the ceiling at 10,000. That's, I think, now a number that we can, over the passage of time, identify as a far too low number to the actual demand of people who are in need of this protection. And similarly, because there is such a dramatic backlog, the administration could use executive power to ensure that there's enough staff and resources at the agencies to ensure that those U visas in waiting are provided with temporary protection and work authorization as soon as possible if they are prima facie eligible.
Okay, we have a question from Maria Bermudez. You know, what can you tell us about the similarities and differences between the deportation of children under the Obama and Trump administrations?
It's another great question, and I haven't specifically studied the deportation of children, but what I have observed is the increased number of unaccompanied minors who are turned away. So they're, you know, in the wake of COVID-19, we've seen that there isn't even a process of detention and deportation, but rather, because of rules that have been put into place, people just being turned away at the southern border. I imagine that there will be a menu of solutions that come out that are specific to children when it comes to limiting or stopping their deportations, limiting their detention, ensuring that they have greater access to counsel. These are some of the remedies that I can imagine has already come out of the woodwork or could for a new administration. I wouldn't be able to speak between the similarities and differences between Obama and Trump because I just haven't studied it.
Okay, you mentioned the pandemic. Here's the second pandemic-related question from Faisal Buhari, who suggests that because of the pandemic, some people may have unintentionally overstayed their visas. Are you aware of any policies that are being proposed under a Biden-Harris administration to remedy that particular situation?
That's a great question, and this is I don't know how much attention it's gotten. I've certainly counseled a number of people in this situation already, and I think that the magic answer is prosecutorial discretion, and that's because the agency has the prosecutorial discretion to relax or suspend, expiration dates during an extraordinary event, right? That's exactly what happened with students who were affected during Hurricane Katrina, for example. So this global pandemic is an extraordinary event where it is more than reasonable to maximize the use of prosecutorial discretion when it comes to those who are, unable to get a timely extension on their visa or even depart the United States on time through no fault of their own.
Okay. Would anybody else like to offer a question or comment here? I see that Apollo's chariot is low in the sky in Pennsylvania right now.
Ingrid. Jump in with another question. One of the things I touched on, is something that I've done a lot of research on, which is, the prosecution of border crossers. And, that's something that got a lot of discussion in the context of the Democratic debates, right, in the context of the presidential nomination for the Democratic candidate. And we do see differences between what Biden proposed and Harris, sort of siding with Castro and others who favored decriminalization, at least of Section 1325 illegal entry crimes. What do you see as being sort of possible given the posture of Congress and, sort of public opinion in these areas?
Yeah, it's a great question. And I think that there will be a lot of people that need to be swayed in order for there to be a decriminalization of unlawful entry. But I do think that an executive and a new attorney general has the power to tell U.S. attorneys, or at least make it a federal policy, that unlawful entry crimes are low priorities for criminal prosecution, right? So in the same way that there are limited resources in immigration, there are also limited resources in the criminal justice system. Even U.S. attorneys and former U.S. attorneys were very critical of the zero tolerance policy because it was not in their normal arsenal to use their limited resources to prosecute people who were not committing dangerous crimes, did not have a victim in their crime, did not have, they'd rather focus on the sex trafficking ring that's taking place down the road, right? Or in their jurisdiction than say, deal with an unlawful entrant. I think the way we might persuade, right, is to press upon the skeptics that this is not the end of the road for anyone who enters the United States without inspection, because they are subject to both a criminal sanction under current law and also a civil one, and a pretty significant one called deportation, unless there is relief available. So I think if people understand that by decriminalizing unlawful entry, there are still consequences that attach when someone enters without inspection, will also help to demystify this idea that we would be in a lawless landscape if we decriminalized unlawful entry.
Okay, we'll close with a question from our co-host, Roger Waldinger, who asks, although you earlier suggested that the Obama administration should not be seen as a model for a Biden-Harris administration going forward, I wonder whether the new administration can avert the types of conflicts that pitted advocates against the administration under Obama. In the end, advocates will always be pushing for expanded admissions, whereas the administration will be responsive to the same type of restrictionist impulses that led the Obama administration in ways that left the advocacy community so unhappy.
That's a big last question, right? And I think that I don't know that any administration will make everyone happy, right? I think that immigration policy is an example of, at least in my short 20 plus years in the field, one of those policies and issues where there's compromise, and you end up in a situation where people I think an administration is not going far enough, and others will think that they are going too far. And anyone who's able to actually fix that, I mean, that's way above my pay grade. But I do think that we are in a new era to the extent that and this gets back to sort of the power of discretion and the degree to which changes are needed are so significant that I believe that a Biden administration has more political capital than what President Obama had to make dramatic changes to immigration policy. The restrictionists are going to be there, but because the restrictions were so sweeping, I do think that provides, more tools in the toolbox and political capital for a Biden-Harris administration to really be intentional about the choices they are making around immigration.
Well, thank you so much, Professor Wadhia. Thank you, Professor Eagly, for sharing your insights. Please join us next week at the same time to discuss many of the same themes that we've been talking about today in The President and Immigration Law by Christina Rodriguez and Adam Cox, with discussion by Hiroshi Motomura. Have a good weekend, everyone, and hope to see you next weekend. Thank you.
Thank you.